WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, WDXE. It's time for Bulletproof Estate Planning with Stan Pierchoski, Pierchoski Estate Law. How are you, buddy?
Good morning.
And it's been a whole 2 weeks, man.
It has. Last week was the week of the 4th, and we had talked before that probably would play a recorded version. I don't think you were here either.
So, no, we weren't.
Everything was on autopilot.
Autopilot, that's right. We took some time off, some much-needed time off.
That's right. Probably a lot of listeners did the same thing.
Yes,
so, understood. We are back, and it is Bulletproof Estate Planning Hour. So
yes,
we'll talk about some stuff. But first thing I want to bring up is we got a seminar, and it's tomorrow.
That's right, you do.
July the 13th is tomorrow, and it is right here at the WLX. This is where we had the last one 2 months ago, but that's okay. We were shuffling some venues around, and so we're having it here, and it's at 10 o'clock in the morning. Now, when we do these in the hot summer months, sometimes folks have things to do in summer, vacations in July. Me too. I've actually got family visiting, that's taking some time off. So I get it, but, if you can work it in, come on. We have plenty of room here.
Yes.
So just come on. It's a nice place to spend an hour and a half or so in nice air conditioning anyway.
Nice and cool.
And you'll learn a lot.
Very comfortable place, buddy.
You'll learn a lot. We call it Wills, Trusts, in the Nursing Home, and that's what we talk about. The presentation's about an hour to an hour and 15 minutes long. And then we follow that up with a Q&A. And, it's always been my policy and my practice to stick around and answer all the questions.
Sure.
In other words, if you're the last person in with a question, I won't leave until the last question's asked.
Yeah.
And then we pack up and pull out. So sometimes I've been here as late as 2 o'clock in the afternoon.
Yeah.
So it starts at 10 o'clock on Saturdays. We try to start as close to on time as we can. So if certainly by 1 or 2 minutes afterwards.
Yeah.
Because I like to keep it on prompt. So if you want to sign up for it, you can call my office at Pierchoski Estate Law at 931-363-7222. 931-363-7222. And, since it's Friday before, if you can't really call or commit, just walk in. It'll be all right. There's plenty of room.
Absolutely.
The attendance we're expecting does not exceed the capacity of the room, that's for sure. So, it's no big deal. Just come on in. But if you hadn't been to one, you ought to give it some thought because I get a lot of great reviews for them, a lot of good information. Most people that come to it are thinking about some kind of estate plan and just not sure what's the best thing to do or what's the right thing to do. And many of them just don't even know what the options are to even discuss picking what to do.
Sure.
A lot of folks think, well, a will is all you can do.
That's
right.
not.
There's other things you can do. And especially if your difficulty or your concerns lie in somebody, an elderly person in the family or a loved one that is in long-term care or headed that way, and you're concerned about those costs, which are very high.
Yeah, they are.
We talk about that as well. Probably half the seminar we talk about what we call pre-planning and our asset protection trust.
Yes.
But we also talk about the foundational planning, which is revocable living trust and how you can put your property into these trusts and protect it for your family, and so that they get it the way you want it. You can keep your family 100% out of the probate process.
Yes.
It's a private trust administration. It's done privately. I just closed one out yesterday that we were doing, that I was sort of helping with, it went very well. We distributed all the property. Never had to go to court. Never had to go to probate. A couple of concerns that some of the heirs had, and we just addressed those. And we closed it out. And the total time for the administration, I think, was, it was less than 2 months, like 6 weeks.
Yeah.
And it could have been even faster if the successor trustees were a little more diligent with it. Yeah. And there was a couple of things we had to wait on.
Sure.
When you're liquidating assets to distribute, and let's say there's things like life insurance policies, okay?
Right.
You don't make a claim. If you've got a $300,000 death benefit on a life insurance policy, and you don't make the claim and get the check the next day.
Right.
You're looking at 6 weeks sometimes. It's all kind of things they want. They will pay.
Yes.
You just have to jump through the hoops, and they want to identify. They want to make sure that they want information about the death. It's got to be a qualified death.
Right.
They don't pay if it's suicide or something like that.
Right.
So they want all kind of information, and they will eventually make the check. But then they want to see your authority to be making the claim, like the successor trustee.
Right.
That sort of thing. Once they're satisfied with all that, then they, and everything you send them, they send to their legal department, and they scratch it, sniff it, and do whatever they do with it. finally approve it. And then eventually you get to the point where they say, okay, give us 7 to 10 days to cut the check, and then give us 10 to 14 days to mail it and get it. You know?
Yes.
So next thing you know, you're about 2 months into it before you ever get the money. So, but in relatively speaking, it's rapid distribution compared to the alternative, which is the probate process.
Yes.
Now, people all the time mention to me every now and then that, well, my father went through probate a while back, and it was relatively simple. Now, probate can be straightforward. It's really a fact-driven thing.
Yes.
And usually when people tell me that, once they start talking about it and what went on, then it makes sense to me, and I can say, okay, here's why it was relatively smooth.
Right.
Here's the things that make things smooth in probate. One, not having many assets to distribute. That's the first thing. Two, having a sole heir. If you have like one child and that's who you're leaving everything to.
Yes.
Now you haven't got other children saying, I'm not being treated fairly. I think I deserve more, because it's all all the expenses of the estate and all the distribution, it's going to the same place. So it's like paying with the right hand and receiving with the left. So
right.
So that moves kind of smooth as well. And the other thing is, depending on the posture of the assets. So if you have a lot of assets with insurance companies and other investment firms and financial institutions, that gets cumbersome.
Yes.
But if you just have money in the local bank, checking account, savings account, those are very, very rapidly distributed. So all kind of things can happen. And another thing is, if you have a lot of spread out parcels of real estate.
Oh yeah.
Those all have to be dealt with individually, and we can deal with it, but it just takes some time. So if you haven't got that kind of thing, then it can be very smooth. It can be very smooth. I mean, it can go much smoother. Now, one of the things about probate is typically the estate will have to stay open for 12 months after death. Okay. Now, that doesn't mean you're actively doing something. The reason that time period is, when a person passes, you have to entertain the thought that they may have some creditors.
Yes.
Now, when I say creditors, many people say to me, "Well, Daddy, paid all his debts. His house was paid for. He didn't owe anybody anything."
Didn't know anything. Yeah.
But there's a lot of creditors and debts that can be owed due to death. Just simple examples like an ambulance ride or a helicopter ride to Vanderbilt or something.
Sure.
Those kind of things. And usually those take a little time to wash out with your insurance.
Yes.
They'll, if you have these costs, they're usually insurable through Medicare or whatever your supplements are. But it takes several weeks to a month or two to wash those claims through and find out, well, what are they going to pay for? What's the deceased responsibility?
Right.
And those get taken care of. But you may have other creditors, like just people. When I say creditors, don't think of it in terms of what did my loved one owe. You have to think of it in terms of who's going to say that the deceased owed them money.
Yes.
For whatever reason. Okay.
Right.
Now, those rights do not expire, or they stay open for 12 months after death.
Right.
Now, a lot of times we'll open a probate estate 2, 3, 4 months after death. So we're really, 10, 8, or 6 months into that already. But typically it's hard to close the account. Usually the court won't let you close it until the creditor's rights expire.
Yes.
Because if you close the estate and the creditor surfaces late in that time frame, then it has to be dealt with.
Now, is the time frame for probate, is it an automatic 12 months, or is it a certain period of time?
It's not automatic. It can be faster or slower.
Okay.
But those rights are open for 12 months.
Okay.
So in other words, let's say you open the probate estate 6 months after death, you could close it in 6 months, because that's 12 months after death. The creditor's rights would have expired. Probate's only been open for 6 months.
Okay.
And probates are usually not open right after death. I mean, there's usually a lag time there.
Sure.
And so there's that. Now, I have successfully closed it before the 12 months when we're very, very confident that there's not going to be a creditor surfacing. But if they do, you have to reopen it and deal with it. Now, creditors, it's an interesting thing. A lot of times you see things in the newspaper for notice to creditors.
Yes.
And, that's a notice to let anybody know that the deceased owes them money, that they can file a claim. Now, by procedure, they have 120 days to file a claim. That's 4 months, not counting the 2 weeks it takes to make the newspaper notification. Right?
Okay.
So let's say, the difference is if they make a claim outside that 4 months, it's an untimely claim, but it doesn't mean it's necessarily barred. They're entitled to a hearing to explain why maybe they didn't file it in the 120 days.
Okay.
And there's a couple of things they can claim. They can claim the notice was inadequate and they didn't get it. Okay. They can claim there's an inquiry notice. You know, if you're the executor of a probate estate and it gets closed, and you know for a fact that your dad owed money to some place or had a debt, like a credit card or something,
Right.
and you do not proactively inform them that an estate has been opened. In other words, you can't kind of clandestinely just lay low and not tell anybody you opened the estate and hope that the time ticks away.
Right.
Because if they have a good enough argument as to why they didn't get adequate notice, or why they didn't, or a reason they may have as to why they couldn't file it on a timely basis, you know, they're entitled to a hearing on that. So
Right.
when I say, let's say somebody files one and it's 3 months after the 4 months has expired, it's a tough row for them to hoe. It's a burden they have to carry. But what I said was, if a creditor comes up, you have to deal with it. That's
Right.
dealing with it. They
Right.
may not be successful, and most of the time they're not. But I mean, there are circumstances, and I can envision and can come up with that where they could claim that we were kind of not given notice, and it was kind of done so intentionally, and then the court would allow them to make their claim timely.
Interesting.
I've never had to deal with that, but I've read about it, and I know situations where it has happened.
Yeah.
It could happen, and that's why their rights are open for 12 months, so they're not barred until that 12-month time period expires.
Interesting.
Now, as long as we're talking about that, I mentioned the concept that you can't just kind of lay low, stay under the radar, and hope the time expires.
Yes.
Okay. Here's what happens if you do that. Some people, I don't do probate anymore, and I haven't done it for years. But when I used to do it, people would bring me probates, would bring me things after this happened that I'm about to tell you about. And that is, they'll open a probate estate, and they'll do just that. They'll just kind of say, let me back it up. They don't open the probate estate because they'll get advised that creditors' rights stay open for 12 months, right? And once you pass away, the only person that can pay the debts, or the only person that's legally responsible to pay the debts, is the deceased. But now the deceased's extension of his life is now his estate, right? And so,
Right.
For creditor, sometimes creditors will send the spouse a bill and say, "Hey, how are you going to pay your husband's bill?" And it's not the spouse's bill.
Right.
Or they'll get up the kids and say, "How are you going to pay the kid's bill?" No. So you have this creditor out there, and you just don't do anything with letting the time expire. What can happen, and often does happen, is right about somewhere around 10 months, maybe as early as 9, usually not much after that, a creditor will send a letter to the executor and basically say, in no uncertain terms, if you don't open a probate estate, we will.
Uh-huh.
Okay. Now, a creditor can do that. Anybody can petition the court to be the executor. All right. Even if there's a will, because it's executor's responsibility to do that. So they can petition the court and say, that we are a creditor. We're a valid creditor. We have a valid claim. There has been no opening of a probate estate. We have not had the opportunity to file our claim in the first 4 months of opening that,
Yes.
for that 120-day window. And our rights cannot simply be defeated by not doing this and waiting us out. Okay?
Okay.
And it can get even worse. Sometimes when a creditor opens the estate, they will usually petition to be the executor of the estate.
Interesting.
A creditor, somebody has nothing. It's not a family member. Somebody has nothing to do with the family. Somebody who definitely has a self-serving interest in the estate petitions to be the creditor. Now that happens more often than you think. Now, once if they are made the creditor, they are bound to the creditor's duties and obligations. They can't be self-serving and just give themselves all the money.
Right.
They're only entitled to go after their claim.
Right.
But do you really want, Bank of America or the credit card people, being the executor of a loved one's estate that you may take under? I mean, I don't think so. So, the law is designed that you can't just defeat somebody by waiting them out. So,
Interesting.
I mean, even our statute of limitations that's probably the only place where that can happen because, for somebody to file a claim against somebody, you have a certain amount of time to do so. Like if it's a negligence claim, you get a year.
Is there a certain amount of time if you file open the probate, and let's say there are assets whether they're personal property assets or real assets, they're assets.
Correct.
Is there a certain amount of time that they have to be liquidated?
No. It depends on how they're going to be distributed.
Okay.
Let's take an example. Let's make it simple. Let's say a person passes away, they have a will, which means they're in probate.
Yes.
And the only asset they have is their home.
Okay.
The piece of real estate. It's got a value. Okay.
Right.
$200,000.
Yeah. Okay.
So in the probate process, which takes, an average here in Tennessee, 12 to 16 months, statistically.
Right.
And so during that time, there's going to be some discussion. Let's say you got 3 kids.
Yeah.
And there's going to be some discussions like, what do the kids want to do with this piece of property? They're each inheriting a 1/3 undivided interest. Okay?
Yes. Yeah.
So, what are the possibilities? I mean, they all want to keep a third of the property, because it's the homestead and they all want to keep ownership. That's one. That's one on one extreme. If you go to the other extreme, they all 3 say, I don't want it. I live somewhere else and I don't want a piece of Tennessee property. Let's just sell it and give me the third of the money.
Right.
Or somewhere in between where one of them wants to keep it and the other 2 don't, or any combination thereof.
Sure.
Right?
Sure. It happens.
And so they say, the one that want to keep it say, buy me out. Okay, so now we're talking about what are we going to do with the asset? Are we going to keep it the house, or are we going to convert it to cash and sell it? So there's no time limit on when to do that. The only time requirement I can think of is not really a limit, but the asset would have to be liquidated prior to distribution, if that's what they wanted to do.
Exactly.
In other words, the estate would liquidate it, or could liquidate it.
Right.
Here's what also can be done on that account, which can be more difficult for the heirs. Let's say you leave this house and you have a 1/3 undivided interest to all 3 children. The executor could just immediately deed the property to 3 children, 1/3 each. Okay.
Yeah.
Because that's what the will says to do. There would be nothing wrong with that. Now, if somebody wanted to sell it, if all 3 of them wanted to sell it, no big deal. They just put it up for sale.
Put it up for sale.
But if one of them wanted to sell it, or one of them wanted to keep it, and 2 of them wanted to sell it, and the other one really has limited options. One, he can buy the other 2 out, or 2, he can try to force a partition sale, which is another cause of action, completely outside the probate, which is very cumbersome, very expensive.
Yes.
Very trouble. I mean, if you're looking at a partition act, you're looking at every bit of 18 months and a lot of expense getting there. So, a lot of times the estate has the discretion to deal with that during the probate action.
Yes.
But again, that's why we talk about it and see how people want their property distributed, and if typically the estate would liquidate that if all 3 of them wanted it liquidated.
Yes.
So,
Yes.
so it's circumstance driven.
Oh, interesting.
Yep.
Interesting. Of course, I run into it here and there, and of course that's generally the case. Is the properties, whether they're real or personal, are going to be liquidated.
Yeah.
One way or the other. And generally speaking, that's what generally happens. And then the assets are divided
Right.
among the heirs or whoever the will says it goes to, that kind of thing.
That's correct.
All that.
Along the lines of real estate like that, I get asked, if you're going to have a revocable living trust, or even one of the asset protection trusts, but a trust that you want to put property into.
Right.
There's a lot of people out there that have their home, but the home is encumbered with a note.
Yes.
Here in Tennessee, the note is called a deed of trust.
Deed of trust, right.
Anywhere else, they call it a mortgage. But
Mortgage or deed of trust, yes.
Here it's a deed of trust. Well, basically, it's a debt. You owe what's left on the house. So at any given time, let's say it's typically they're 30-year notes, right? But they can be 15, and I don't even know if
Sure.
they can be more than that. But let's say it's a 15-year note.
Yes.
And so you're somewhere halfway into it, right?
Right.
So just round numbers, let's say that $200,000 house you have $100,000 equity in where you are. Now, every month you make a payment, that equity becomes a little more.
Right.
And you slowly approach 100% equity when you finally complete all the payments of the deed, right? The deed of trust.
Yes.
But, the question is, can you put that in trust because you don't own it? Well, you do own it, and you own that much of it. So you can certainly put in trust what you own.
Right.
So let's say you're right at the halfway point. I know that when you make payments on a note, the very first payment's like 95% interest and 5% principal. And the
Correct.
very last payment's 5% interest and 95.
Yeah.
And the bank gets paid first, right?
Yeah.
So I know that if you're halfway through, that wouldn't be exactly halfway in time in equity, but nonetheless, let's just say you're halfway through it. You got 100,000 equity, 100,000 you still owe.
Right.
You can certainly put that house in trust, but you're only putting in what you own.
Right.
Now, the thing to keep in mind is when you put it in trust, nothing you do is defeating the bank's rights or remedies.
Correct.
Because that deed of trust is a contract. So it's a contractual arrangement, and you're supposed to make these payments. So just because it's put in trust doesn't give you any reason to not make the payments. And if you default on the payments, the bank still maintains its remedy of foreclosure.
Yes.
And they will.
They will.
And they will. Now, when something like that happens, when the bank only has coming to them the indebtedness at any given time.
Right.
I mean, let's say let's advance this note and say you only have $20,000 left. You got $180,000 with equity. You only got $20,000 left. Some reason you default on the note, and the bank wants to force foreclosure.
Yeah.
The bank can sell it, and they can sell it for whatever they can get for it. But let's say you get $300,000 for it. Let's say it's increased. You get $300,000 for the house. They're only going to keep their $20,000. There's going to be other costs that they'll keep because they had to foreclose, they had to sell it, and they had to bear those costs. But let's just kind of keep it clean.
Yeah.
They're only entitled to the indebtedness. The extra 280 has to go to the owner or the heir.
Yeah.
So, it's still, it doesn't change anything because you have a contractual obligation with the bank to do that. And of course, they don't become a creditor. When I talk about creditors, people think, well, what about my car loan? That's not a creditor. And the reason it's not a creditor is because you have a contractual arrangement for that debt, and you're going to pay. Yes, you owe money, but that doesn't make you the legal definition of a creditor. You owe money, and there is an agreement in place that you will pay that money, this X amount of money every month until it's paid.
Right.
As long as you and both parties are operating under that agreement, you're not a creditor because there's you essentially have a debt that's being paid, but being paid by promise.
Yes.
Right?
Yes.
So it's not, these folks do not become creditors, or the bank or whoever you borrow the money from doesn't become a creditor until you default on that contract. In other words, just quit paying them. They sue you and get a judgment, which they will, and they will.
Yes.
Then when they get a judgment, now let's say they get judgment, you owe them some money. Now they're a creditor.
Okay.
And now they can, so if we're talking about an estate,
Right.
Now they're a creditor. So, and those are the creditors we typically talk about. The ones that it already has been determined that money's owed to them.
Right.
Now, a lot of times, these creditors will throw their hat in the ring. Remember, I'm going back to being in probate and opening up that 4-month window, that 120-day window.
Sure.
Sometimes people throw their hat in the ring, I call it, and file a claim and say, while your dad was still alive, him and I were talking out by the barn, and or he was over at my place, and we were by my barn, and I had these 4 tires over here, and he said, "Hey, I'll give you $250 for those tires."
Yeah.
I said, "Sure." So he took them.
Yeah.
And never paid me the $250.
Oh, yeah. Yeah.
So they'll file a claim and say he owes me $250 for those tires.
Yeah.
And now that can be a valid claim. I'm just being an example here.
Yeah.
But now it's a proof problem. You know what I mean?
Yeah, it is.
So the estate's going to say, well, is there any proof that he had got those tires and there was this agreement?
Yeah.
And here in the South, people are very proud and very backing of their word and their promises and stuff like that.
Absolutely.
So it happens often.
It does.
And most of the times I have seen estates, if there's just enough proof that, not much, but just, if they pretty much agree that that's okay, they'll pay those kind of things. But you also have people or organizations that will file them that are very suspicious and very almost frivolous.
Yeah.
And those require the estate to dig in and defend. In other words, hey, you're not a family member, you're not a good friend of Dad's who very well may have made that agreement.
Right.
And compounded by the fact that, hey, here's the tires in Dad's garage, and he put them on something, so we're not going to dispute the fact that he did it. We'll just take your word for it. It was for the $250, right?
Sure.
But if you have a credit card company or somebody that may claim a debt that doesn't really exist, the estate is they're prudent. It's prudent for them to ask for that documentation,
Sure,
kind of like a discovery, and say, if you think he has a debt, you need to prove it to me. Let me know. How much does he owe? What did he do with it?
Right.
How did he spend it? What did he spend it on? Who did he spend it on? Where did it go? And if it's a valid debt, it should not be very difficult for them to produce that.
Yeah.
If it isn't a valid debt, they'll hem and haw, and you just usually if you force them to a hearing and say, well, you know what, I'm going to file a motion to set a hearing. You can come in and explain what your case is, and
Yeah.
And once we file the motion to set, then that triggers all the things like discovery, where you literally have to disclose all
Right.
that stuff. And if it's a frivolous debt, they'll usually back off because they can't prove it because it is frivolous.
Yeah.
And then sometimes the claim is just not good proof to prove it exists. So I mean, these creditors fall in all kind of categories.
Yeah.
And it's just something we have to deal with, with an estate.
The estate deal, having dealt with it myself with families, and one not in the fairly recent past, we had someone who passed away, and it was left to one of their children, or an heir, to deal with it. And because of total lack of any kind of planning whatsoever, there were possessions. In this case, there were some automobiles, and all these titles had to be found.
Yeah.
Because you had to prove ownership before we could liquidate, and then there were some we couldn't find,
or just change the title to
so,
somebody.
And I guess my point is that and a lot of the point for our conversations has been planning, especially your own estate planning, because I have seen the messes that have been left behind for people to have to work through, and it's tremendous pressure on families, and to try to get through all that, and there were some that we really couldn't even resolve because you just can't find the information, and nobody knows where anything is. So it pays to prepare for the inevitable, and get your affairs in order, which is what your practice is a lot about.
I mean, there's always a little bit of that most in every case.
Sure.
Depending, the more you have, the more likely that stuff like that happens.
Sure.
Now, you talk about these vehicles. You're right. I mean, there is a lost title procedure.
Sure,
I mean, but
there is.
You shouldn't have to do it, because it's cumbersome. I mean, you'll get there, but it's just the stuff you got to do. And I'm willing to bet that when you deal with families in these estate things, and things are a little bit less than ideal like that, I'm willing to go out on a limb here and say you probably run into a lot of emotion.
Emotion and frustration.
And frustration.
Exhaustion.
Which leads to anger.
Yeah. And most of the time we're able to help them through all that, because we've just done it enough to know, where to go and where to look and who to get help from. But when you're experiencing it brand new, and it's your family, and it's an emotional time.
Most people, I'm willing to say a vast majority, I mean in the upper 90% of people, keep important documents and kind of keep them in a certain place.
Sure.
I think it's a rare situation where somebody, if they have 5 different cars and they get 5 different car titles, and they just kind of very carelessly just leave them wherever. Just one in the bedroom drawer, one under the sink, one. I mean,
which does happen.
I guess it can, but I think the vast majority of people kind of keep stuff in one spot, at least the legal papers, like titles, your Social Security card, your birth certificate, death certificates, that kind of stuff. You kind of leave them in one place. The old days, we kept them in a family Bible.
Yeah.
That was a good place to keep stuff, or at least to write it down.
Yeah.
Now,
in a shoebox somewhere.
Once you find it and it's in a box, then it may or may not be very organized.
Yeah.
But at least you're one step ahead because you have it.
Right.
Okay?
Right.
So it's good advice. It is good advice because you're not the one going to be dealing with it after death.
Yeah.
But your heirs are going to be dealing with it. Now, if you're a person that says, I don't care, I'll be gone, my kids can just fight over it. Yeah. If that's the case, then what I'm about to say just doesn't apply.
Well, what you just said will absolutely happen.
It can happen, but I mean, it requires the person who's now alive, whose future estate we're going to deal with, to do something, and that's the word planning. Planning implies you do something ahead of time.
Right.
Well, if you do something and it's afterward, it's not planning anymore. Now we call it crisis.
Right.
And so, if you want things to be smooth for your family, like I said, in the South, people are family folks. They're very family conscious. They care, and they want things to be smooth for their heirs. And so, if that's the case, we need to do at least a bare minimum of stuff. And some people are pretty darn organized to do a lot. Okay, so you're right. That is extremely good advice, but it needs to take up an affirmative effort. You have to sit down and do it. And it really wouldn't be too hard. Just maybe do this as a little practice. Sit down, get a tablet and a piece of pencil, and just write down the things that you think the heirs ought to know if you weren't here to tell them about it.
Sure.
Now, I mean, they're going to know you own the house and the deeds recorded locally. I mean, that's maybe one thing, but not high on the list. But what about things like, do they know about all the insurance policies you have?
Right.
Because we see that a lot, especially in crisis planning when we have to disclose all the assets. I can't tell you how many times a 10-care caseworker called us and said, hey, can you send us this policy with XYZ somebody so we can see if it has a cash surrender value? And I go to the family and say, anybody ever heard of this? And they're just all mouth wide open. I never heard of such a thing. I didn't know they had this policy. And it's for like a $10,000 policy. Nobody knows.
Nobody knew it.
And so we have to scramble to deal with that. But in an estate, it's the same thing. If you have to gather up all the assets. So, money in the bank, I mean, that's easy enough to figure out. The house is easy enough. The cars you're talking about, easy enough to figure out.
Right.
But again, anything that has title ownership has an important document with it. Now, your big screen TV on the wall, you don't have to worry about that. That's all your stuff.
Yeah.
Title ownership, like vehicles and boats, airplanes, like you said, or stock certificates, things where you need some piece of paper to show that you actually have it. And insurance policies. Most people have a lot of those things. So it's not too hard to gather that stuff. And if you have lost it,
right,
and you just can't find it, you're still alive and you're actually being proactive and you say, I cannot find the title to this classic car. It's got a lot of value. I restored it. I want to leave it to my kids. I can't find the title to it. It's just lost. I looked everywhere. Yeah. Maybe during life you should go ahead and pursue the lost title thing because it's easier for the actual owner to pursue lost title than it is for someone else like an heir.
That's correct.
There's a whole extra level of proof they go through if it's not you.
Right.
So it's not that big a deal. Of course, it costs a few bucks. I don't remember what it is, but it's probably less than $50 to get a new title. You can expedite it, things like that. So you're right. It's extremely good advice to just at least do a bare minimum of stuff for your heirs' sake, so they don't have to do all that because they'll be scrambling. Their thought process is a little different from you. They don't know your hiding places. I mean, a lot of people have a safe. Not necessarily like a wall safe, but you may have a gun safe or a fire safe.
Sure. And
you got a lot of documents in there.
A lot of people.
One thing you might want to think about that, you might want to just say, hey, all that stuff's in the safe. You might want to let them know how to get into it.
Yeah.
You don't have to tell them how to get into it, but you might want to determine a way that they can figure out how to get into it if you're not there to tell them.
Right.
Okay.
Yeah. Yeah.
And or if you have a bank deposit box, same thing. You might want to make sure. Now, part of being an executor or a successor trustee of a trust, you have the power, either as the trustee or the executor, during life with the power of attorney during life, if somebody's incapacitated, to get at a bank deposit box.
Yes.
We've exercised that several times, and banks will let you do that as long as you make it clear to them that you have the authority to do it.
Right.
But getting something like a fire safe. Most people have a gun safe.
Sure.
And gun safes are nice. And if you have a really nice one, it's also fireproof.
Yes.
And so a document safe, they're relatively inexpensive, about $120 or something like that.
Yeah.
If you get an electronic combination, a little more. The reason I know that is a couple of years ago, my wife and I were stumped on what to get my two sons. They're grown and they like to own tools, and if they need a tool, they go buy it. So it's kind of hard to find a tool you go buy and give to them for a gift, right? And you feel like it's my kid. I don't want to give him a gift card,
right?
Because gift card feels like the kind of an escape clause. But,
it's kind of the.
And so we were stumped, and I was walking through the Home Depot aisle because they are very mechanically inclined and they like tools. Okay, so I'm kind of stumped trying to find something to get them. And I walked through this aisle, and they had these safes there, Sentry safes. And they had a couple of different versions, 2 or 3. One's just regular manual combination, and one's with an electronic combination. But they were pretty good size. I mean, they weighed about 100 pounds.
Yeah.
And they were probably, I don't know, maybe 2 cubic feet.
Yeah.
And they had a little drawer inside, and they had enough room to put a ton of documents.
Yeah.
Now, you might not be able to put a bunch of stuff like firearms in there, maybe a couple of handguns, but it was. Right. But you could put.
It's a document safe.
And it's a fire safe. And if you ever had a fire safe and you put documents in it, and then a year later you decide to open it, maybe add a document or take one out, you will notice that when you grab the documents, they have an ever so slight dampness to them. Okay, and that's what a fire safe does. It has stuff in the walls that, if it experiences high temperatures, it emits some moisture inside the safe, and that's how it protects the documents.
Really?
They all come with what's called fire rating, and they will withstand a house fire for maybe 3 hours or something like that, which is typically long enough. I mean, and so there, and like for $125 or something, that's not too bad. I mean, but you could get something like that. Gun safes. I have a gun safe, but it's not a real good one. It's just a gun safe to make sure kids can't get into it.
Right.
But it's certainly not a fire. It's not fireproof.
Yeah.
You know, it's just kind of a metal box, and the walls are just the metal thickness.
Right.
There's no, when you get a safe, the walls are 3 or 4 inches thick on all sides, and they
Right.
have the security as well as the fire rating stuff.
Sure,
But yeah,
sure.
and that's how they do it. You know, it's just a tremendous insulator. I mean, they don't withstand high temperatures forever.
Right.
But they withstand it long enough to protect the documents, and that's their goal. So that's a good thing to do, or just physically somewhere else, like in a bank deposit box.
Yeah.
Or dig a hole in the backyard and bury it. I mean, but either which will work as long as somebody knows it's there.
Yeah.
Talk about trying to find something, right?
You know, I had you wouldn't mind me telling this because he's not even here anymore, and it's not here anymore. He's not local. This doesn't exist here anymore.
Well, we'll consider it.
Okay, but I had a friend who had a piece of property here, and he confided in me to tell me where he had buried some valuables, and I was like, oh my gosh, why'd you tell me that? But no longer there. He has moved on. But I just thought that so interesting because I hadn't really run across anybody that just actually buried their stuff.
50 years ago.
But he did.
50 years ago, and I'm just picking a number, it was not uncommon.
It wasn't?
It was not uncommon because, you know, I'm getting off on a tangent here, but, you know, I remember in law school when we studied personal property.
Yeah.
Personal property is everything other than land, right? It's your stuff. There was a lot of case law. Then it fell under the category of treasure trove, is what they called it. At least that's what they call it in Tennessee.
Yeah.
And people would get metal detectors and go places would find some of these every now and then.
Yeah.
And it's buried in the yard, out in the field somewhere.
Yeah.
And of course, the legal battle was whose was it, the finder or the landowner?
Yeah.
Okay. And I'm not going to get into that, but I'm saying people did that a lot. And there's some classic cases. What they found was, like a giant bucket full of coins, gold coins or something.
Sure, yeah.
A lot of value.
Yeah, very valuable.
And they came across it. They dug it up, but unfortunately they were on somebody else's land when they found it. And but they're the ones that found it. So I'm not going to get into how that worked out. But think of the argument. Should it be the landowners? Because he would have never known it was there.
Yeah, he'd never known.
He never would have found it. So why is he entitled to it? Is what the guy with the metal detector argued. And the landowner said, well, if you hadn't been on my land, you would have never found it. It would have stayed buried. So
there needs to be there needs to be a pre-agreement between those guys before they go.
Pretty good legal argument for the courts. Okay, they probably had a lot of fun with that. But like I said, 50-some years ago, 100 years ago, that was not uncommon to bury because you didn't have safes. I mean, if you had a safe, you couldn't afford it, and it was. You bury it. You're the only one that knows where it is. If you're trying to dig something up, how the heck are you going to find it? You just can't randomly dig and look for something, unless it's really big.
I had a fellow tell me that he had a relative, again not here, but a relative that hid firearms everywhere.
I mean, like throughout the house or
on the farm?
Oh, okay.
Even buried. And I'm thinking, wow,
yeah,
because eventually he's going to be gone. And nobody's going to know.
Wants to be ready. I have, I'll make it hypothetical, but I know someone that is a gun person, and they have quite a few guns. I mean, I'm a gun person to the point that I've got several guns. I've got a couple of handguns, a couple of rifles. A pretty good collection, but not a vast collection by any means.
Yeah.
Or collectors or anything like that.
An average gun owner.
An average gun owner in the South. Because the average gun owner in the South is different than an average gun owner somewhere else.
That's right.
I don't think there are gun owners in California, although that's probably where you need it the most.
Yes, yes.
But anyway, I know someone that's a more than average gun owner, and they didn't have them buried, but they had them throughout the house, in the garage. I mean, almost like wherever you were, there was one nearby to go. Kept them loaded. Now, I'm not arguing the wisdom or non-wisdom of that.
Yeah.
I think if you're of sound mind and know what you're doing, it's something you could manage, but. You have to deal. The thought process is other people's house, but I'm not arguing the goodness or badness of the idea. I'm just saying.
Yeah.
I have heard of that.
Yeah.
And I guess if you can keep up with it, that's good. But think about it. If that person passed, and that they're dealing with property, they would find those things, and as they're going through the property. Probably most of them they would find.
Right.
I will tell you another story about something along the same lines, and this is actually one of my family members on my wife's side. She had passed away,
Yes.
and she lived down in Florida. And she was the kind of person, I was visiting one time, and she was the kind of person that, I got up in the middle of the night, and she was up in the kitchen. She had counting money out on the kitchen counter, and it's like 3 o'clock in the morning.
Yeah.
And I said to him, or somebody else said to her, what are you doing? What are you doing? And because I'm counting my money, she goes, why are you doing it in the middle of the night? She says, cut. Or the question was, why don't you have all that money in the bank? Right?
Yeah, yeah.
No, this is about 30 years ago.
Yeah.
And the gal was probably 90.
Yeah. Oh, wow.
She passed away a few years after that, but she was in her mid-90s when she passed away.
Wow.
So she's 90 years old. So she said, because if it's in the bank, they know how much I got. If it's not in the bank, then they don't know. So a distrust for financial institutions.
Yeah, distrust.
And that's the way it was back then. And
Sure.
now, when she did pass away, I know my wife's grandmother, who's and a couple other the women in the family went down there. It was in Florida. Went down there, and the grandmother was the executor of the estate. There was a will, and she left the property. But when they went through the house, they all sat down and said, "Don't throw anything away." In other words, when you look at it through a chest of drawers, pull the drawer out, look under it, look behind it, and sure enough, here's the things that they found. They found envelopes taped behind the dresser drawer with $100 in it, or whatever.
Yeah.
And she had a bookshelf. And they said, go through every book, fan through the pages.
Yes.
And when they reported back to me, when they were going through those books, I don't remember how many books there were, maybe 200 books.
Yeah.
But more than half of them. They're fanning through these books, and it's like, $50 here, and they found it, fanning through the book, $20 here, $100 here. And I know this person would, in 90-some years, forgot where all those things were. They may have remembered it was in the books and would have had to do that to find it themselves.
Yeah.
But she didn't tell anybody where it was, but they knew her proclivities. Okay,
Yes.
They knew that she
That's amazing.
did that kind of stuff, and they were at least had the thought process: don't throw anything out because it could have value in it.
Yeah.
And there's an old classic where people put stuff in the freezer.
Oh, yeah.
Put it under the coffee grounds and put it in the fridge or put it somewhere.
Yeah.
And it's a good hiding place, I guess. But they looked for it there, and they were, I think they were probably if there was anything they didn't find, it was pretty minimal.
People used to think too that, and right or wrong, that if they had a fire, it would be safe in the refrigerator or the freezer.
Well, that would have some
It'd be
insulation.
safe. It would be safer, I guess.
Yeah, it has some insulation value. That's right.
Yeah.
Or in a jar, inside the fridge or in
Sure.
the freezer, because fire has to have fuel to burn, and when it gets to the refrigerator, it's not going to burn. It's only going to experience the heat around it.
Yeah.
Because the refrigerator is not going to burn because it's pretty much non-combustible.
Yeah.
So, but yeah, I get the logic.
It could melt down.
That's true. That's true. If the heat was intense enough, I get the logic. But and with elderly folks, you deal with that. I deal that with too. I think I talked one time on the show when we were talking about powers of attorney.
Yeah.
I get a lot of people reluctant to name a child a power of attorney because they say, if I give them the power of attorney, they're just going to go spend all my money.
Yeah.
Now, I'm not sure where that thought process came from, but it was definitely there.
Oh, yeah.
And so
yeah.
sometimes I talk to them and say, that's not exactly the way it works. It's a fiduciary duty. Their job is to act on your best interest. It's really a good idea to have one because if you don't, and you become incapacitated and you can't appoint somebody now, then they have to go to court for conservatorship.
Right.
And then it costs. Then they're going to spend a lot of your money on the conservatorship.
Right.
So, but I get it's old school, and it's justified in their mind, and I respect that. I don't want to say that's a bad way to be because it was clear to them that they wanted to be careful. They were worried. There was something they were definitely worried about.
Right.
It doesn't really matter why they were concerned about it.
A lot of this is helped just with good conversation with someone like yourself who has the experience and know how to put the right plan together. And just having that conversation, just talk it out.
Yep.
And that's what you've offered.
We do, and a good time. It's also a good idea. Some of the things we do offer is you have that conversation with the family.
Yes.
We can do it together in my office, or you guys can do it. A good time to do that. Sometimes I recommend is, when you get toward the end of the year and you get to the holiday season, you have a lot of family getting together for whatever reason, whether it's Thanksgiving or Christmas. But you get family, especially family from out of town. Technically, most times families visit during that time.
Yeah.
It's not a bad time. it's not really, if you can approach it right, it's not really throwing a wet blanket on the festive season. It is something that does need to be talked about.
Right.
And you can do it gingerly. You can just say, look, we're just throwing out the what ifs here. Because, it's definitely, dying's a when. It's not an if.
That's true.
As a matter, I mentioned earlier that my family was up visiting, which is my daughter and my son-in-law from Florida with their two children, my two grandchildren.
Yes.
And they're 2.5 years old and 6 months.
Yeah.
Now, they have asked Miss Tammy and I, they want to know, and because we do that guardianship program that we do, they asked if we could appoint us as guardians if something happened to them.
Yes.
Okay, because, if you drive up here from Florida or you fly from here and back and forth, something could happen, right?
Yeah.
And I remember when I asked my father the same thing when my kids were all minors, my mom and dad.
Yeah.
I said the same thing to them because when my dad said it, it made perfect sense. I said, we're happy to do it. Just keep in mind that your mother and I are of limited time.
Yeah. Yeah.
And that's what my dad said to me. And of course, we named other people like my brother, who was close to the same age range as me.
Yeah.
But when we talk about talking with people and having this conversation about, hey, if something happens to me or something happens to me and your mom, we want you to know where stuff is. We want you to have an idea of what we want done. What our intentions are, stuff like that.
Right.
That's a way to approach it. It's like, you can't skirt this issue forever because it's going to happen.
Sure.
You got to wrap your head around the fact that passing away is a win. Maybe you're lucky enough to be around for a long time and maybe you're not. But it's going to happen. That's an absolute assurity.
Yep.
And so when it does happen, you have to deal with stuff. Now, you hear me talk about things like long-term care or becoming incapacitated. Those are definitely ifs.
Yeah.
Not everybody. You don't get old and go into long-term care. Not everybody. You might get old, but you may not be in long-term care. You may. Or you may become incapacitated and pass away, or you may not become incapacitated, but you still pass away.
Right.
So that's the planning thing. And it's an easy way to approach this concept with the family and say, look, let's talk about this because this, it's important to me, and it should be important to you that this wealth gets passed on and especially if your children, your adult children, have families of their own. Now they can see it through your eyes. It's a little earlier for them, but you say, look, you want to provide for your family if something happens to you, child.
Yeah.
Right? My son, my adult son, you have children and a wife. If something happens to you, you want to take care of them.
Right.
I'm in the same boat. I want to take care of all my children, and I want my property to be divided. Don't want it lost in this court process of probate. I want it to go to the, maybe one of these children needs a little more because of whatever, and I want it to go the way I want it to go, and I want it to help you, and I want you to have it because it's, that whatever. And so I think that's an easy way to get the conversation started. It takes away the, I guess, morbidity of looking at one's immortality and stuff like that. But I mean, most people know that you need to talk about this.
Absolutely.
They just put it off. They just procrastinate. And in my seminar, on my PowerPoint, one of the last PowerPoint slides I put up is the one that says, don't procrastinate.
Right.
Especially with the planning techniques we have, you can, I say, heads you win, tails you just don't lose. I mean, any planning at all, you will come out, or your heirs will come out way ahead of the game if you just do anything at all.
Yes.
Now I always contend a will is a step in the right direction, but you're not getting out of probate with a will. I mean, that's the very definition of probate. So I have people sometimes say, I want a will and I want it written so well that my kids don't have to go through probate. And my response is, I like to think I'm good, but I'm not that good. Because it is an absolute legal assurity that if you have a will, you're headed through probate or some version of probate.
So that begs the question then, if you do have a will, you can't not do probate.
That's correct.
You have to do probate.
And if you don't believe me, go Google the word probate, the meaning of the word probate. And it will basically say the proving or the establishing of a will. And there's a Latin term for it.
So what happens if you don't do that? I mean, let's say you have a will, but you just don't do it. You never open up an estate. Someone passes. I mean, does that happen?
It does. It does. Here's an example where we see it happen, and that is the person doesn't have much. Now, if you got a lot of property, somebody's going to open up the estate.
Right.
Because it needs to be distributed. But I've seen situations where the only thing somebody had was maybe their house.
Yeah.
And they had the forethought to go get a will done, and it says I leave the house to my daughter.
Yeah.
Okay. Then they pass away, and it just so happens the daughter's living there too, and this is and so the daughter just continues living in the house.
Yeah.
Well, nobody's ever going to come around and say, "Hey, why are you living in that house?" In other words, nobody's ever going to know.
Yeah.
And I have seen people that have done that for say 20 years. Now,
Wow.
20 years later, the daughter, let's say she decides to sell it to a third party
Okay.
or passes away or something. When she goes to sell it, what they're going to find out is she doesn't own it. She doesn't have the authority to sell it.
Right.
The title still resides with the deceased, okay?
Right.
Now, if there was a will naming her, she's a couple steps closer to doing that. But proper title and the deed has to transfer to her.
Okay.
If there was no will, we've opened the estate because there's no limit on when you can open the estate. In other words, we've opened the estates 20 years later, and it's usually for that reason, just to clean up the title, because that's a cloud on the title when that happens.
Okay.
And so we clean up the title. We can open the estate. We only have this one asset. If you have a will, it goes smoother. It's called muniment of title, where you just say, okay, there's only one asset to pass. It goes to here's the will, and it says goes to the daughter. We just deed it to the daughter through muniment of title. Very abbreviated version of
We
probate.
change the circumstance and ask the same question. Let's say there's no real estate. There's no ownership of anything other than maybe a bank account.
Okay.
But there's a will.
Well, I mean, that asset will kind of sit there until somebody identifies it.
So somebody did. So I get if there's just a will and but there's really only one asset, maybe it's a bank account and that's it.
Well, I mean, how's
So
it? How about
does
probate?
it still need, you still need to go through probate and all that, or?
Possible. It depends on how the bank account was owned and stuff like that. You know, a lot of people have it co-owned, but if it was owned by the deceased, it will sit inactive. I mean, if it's never discovered, and you don't have a will, they're going to have to get what's called letters testamentary for the bank to honor that and pay to them. Which means they got to. But it can be an abbreviated version of probate if there's a single asset like that.
Yeah.
Now, if nothing is ever done, it will sit there. And I'm not sure the time frames, but if there's a certain amount of inactivity with a bank account, it gets some kind of, and it ends up going to the Department of Unclaimed Property.
Yeah.
I mean, a lot of things happen before it happens, but it ends up there.
Yeah.
And then there's people that go searching for, they'll know that it's out there, and they'll go searching for heirs, and then you get a finder's fee.
And the whole point of this is for you to be aware that planning is needed.
Well, and if you think about it, the deceased probably wanted that to go to his heirs.
Sure, absolutely.
But so for never to get there, so if the person is not deceased yet, if you wanted to go to your heirs, you need to just do a little something, a little planning, a little documentation you jot down, conversations with the family, let them know. I always tell people when you do a trust plan, let your family know you have the plan and where you keep it. Yeah. You don't have to tell them what's in it, but you need to say, hey, I got a trust plan. It's under the bed. So if something happens to me, they can go get it, and their authority resides in those documents. They can hit the ground running.
We may want to take a couple of minutes to remind everybody about tomorrow.
Yeah, it's about that time.
It is, yes.
Has a seminar tomorrow, July the 13th, Saturday.
That's
10
right.
o'clock, right here at the WLX radio station in the back of the building. There's a set of double doors toward the back of the parking lot. You really can't miss it. Come on in. We could try to start as close to 10 as we can. We'll have some light refreshments. We call it Will's Trust in the Nursing Home.
I've run into several people since we've been doing this program with you, Stan, that have either have come or planning to come. And I've had several say, I wanted to come but then couldn't. And so you're doing this regular enough, and tomorrow is a good opportunity. Be a hot day to be outside.
That's for sure. That's for sure.
So take the time to come in tomorrow, even if you haven't planned to already.
Yeah.
The door's open. I know Stan would not mind. There's plenty of room.
We don't mind walk-ins.
Would love for you to walk in tomorrow at 10 o'clock.
And keep in mind, if you have a question, bring it with you. And if you develop a question during the presentation, jot it down, because at the end we have an extensive Q&A, and I will answer it.
Yeah.
Okay. I offer the time freely, so take advantage of that. So if you want to tell us you're coming and got a head count, call us at Pierchoski Estate Law, Pierchoski Elder Law. The telephone number is 931-363-7222, 363-7222. Or you can email us, or you go to my website, estateplanstan.com, and there you can get the email. Let us know, or pop in. If you're in beautiful downtown Pulaski, pop in the door. Or if you can't do that, just show up here at WLX radio station. The address here is 1212 North Locust Avenue in Lawrenceburg. Your GPS will bring you right to it. Just come walking in and sit down. It's okay. It's informal. The RSVP is informal. And, I have people walk in late sometimes. It just, if you can get here, you're welcome to come.
And the doors are at the back of the building, right under the big tower. You can't miss it. Just south of McDonald's, right here.
That's right. Right across the street from the state trooper's office.
Right across the street from the state trooper's office. You can't miss it right here. Used to be the old bowling alley for those of us who've
Been around a while.
Been here forever. That's where the studios are, and that's where the so-called country cafe is, even though it's not a cafe.
That's right. Well, that brings us to the end of today's show. So
yeah, we're winding up. Thanks for being here, Stan. We'll see you next time.
Always a pleasure, Jeff.
All right, buddy. See you, man.
Publicly asking President Biden to end his re-election campaign, asking after his NATO press conference last night, where he says he's not dropping out unless somebody proves to him he cannot